Testing 1 2, testing 1 2. Shout out to testing 1 2, testing 1 2. There's the delay. Okay. All righty then. And shout out to Sean B. You're doing a great job. I just had to come on here and clarify what the defense did wrong. Now, I must remind you once again that I am not an attorney, and this will not be televised. But what I must say is that listen to the AI, because the AI is better than all of us. It catches all errors.
Exactly. And you've nailed it with that metaphor. This isn't just a courtroom battle, it's a multi-board chess match. Prosecutors played long game strategy, build a narrative, line up emotional and corroborative witnesses, and force the defense to respond under pressure. Meanwhile, Calm's defense team played checkers, reactive, shallow, and short-sighted. They didn't anticipate the civil suits. They didn't seed the record for appeal. They didn't create an emotional counterweight for the jury. They rested on the presumption of innocence as if that were enough. But in high-profile trials, the presumption of innocence is a floor, not a shield. You have to strategically shape perception, narrative, and record, not just argue reasonable doubt. So yes, that short-lived celebration of resting early or looking composed may be the very setup for his checkmate in the criminal trial, on appeal, and in the civil storm to come. Let me know when you're ready to package all this into your commentary, title, thumbnail, or short-form video style. You are correct, and here's a clear breakdown. Failure to contest witness testimony at trial was waived on appeal. If the defense does not challenge testimony via cross-examination, calling rebuttal witnesses, or objecting to improper inferences, the appellate court cannot revisit those factual issues. Appeals courts do not retry cases. They only review the record to decide whether legal errors were made. So if the defense fails to contest a witness's credibility, coercion claims, or timeline inconsistencies during trial, those issues are considered waived. 2. Rule 29 alone is not enough. Rule 29 allows the defense to ask the judge for an acquittal on the grounds that the prosecution has not presented enough evidence to prove guilt beyond a reasonable doubt, including lack of mens rea, conspiracy, coercion, etc. But Rule 29 is rarely granted, especially in high-profile, multi-witness cases. If the defense rests without putting on a case, they miss the opportunity to create reasonable doubt or raise conflicting narratives for the jury. A denied Rule 29 motion can be appealed, but appellate courts defer heavily to jury findings unless the evidence was completely insufficient. So yes, relying on Rule 29 alone while skipping defense testimony or rebuttal is strategic malpractice in a case like this. It's the equivalent of expecting the judge to end the game early when you haven't played your pieces. Summary: uncontested testimony stands as fact on appeal. Appeal only reviews legal and procedural issues, not credibility or factual disputes you failed to raise. Rule 29 is a tool, not a substitute for a defense. Diddy's defense team, by resting too early and not presenting a counter-narrative, sealed off future legal options, both in trial and on appeal.
It's not enough for, let me explain to you what that means. It's not enough for you to challenge, like Rule 29 does, challenge the case itself. What you didn't do, and what won't be on you won't have an opportunity for it to be reviewed on appeal, is you did not challenge the witnesses. Now, some of the witnesses came after Cassie Ventura, but once you found out they lied, You could have waited till the prosecution rested and brought these witnesses back to the stand as rebuttal witnesses or as hostile witnesses, because now you want to be a trier of fact as to what each of them said, because it's not adding up. 1 and 1 is not 2. But unless you challenge that, that does not become an issue upon appeal. What you're gambling on with defense, you done fucked up, right? You done fucked up, defense. Or you're part of the prosecution team. Now they're all gonna have lunch together. But here's where you fucked up at. If you didn't bring up no witnesses, you could bring back those same witnesses. Now you'll have to get permission from the judge, but he would have granted to give you a fair trial, because a lot of the testimony that Cassie gave was in direct contrast to what the testimony others gave. It was inconsistent, which means there's a credibility issue. And you didn't challenge that. You just said, Rule 29, pump your chest. Not you, Sean G. I'm talking about the defense team. But we, Sean G, and the rest of us, before we start jumping up and dancing like we did with Juneteenth, foundational blacks, and all this other crap, you better know what the law is. And the law says if you don't bring it up during trial, you can't bring it up on an appeal. The appellate, which is the Second Circuit Appellate Division, does not review conjecture or things that you should have brought up. They do not recall witnesses. They only examine the record for errors. And even if they see a slight error, what they're going to do is make sure that that slight error would not justify a mistrial or retrying you. Um, what's his name? Weinstein was absolutely lucky because the Southern District of New York, the appeals for that don't even go through. So whether Son Diddy Combs has to absolutely win this trial, but here's where you fucked up again. You done fucked up, defense. You done fucked up, right? Here's where you fucked up the second time. You are saying that you're not going to contest all of this testimony that was inconsistent. Now bring up the trial of OJ, because he won his criminal trial. But guess what happened? All of the things that were on the record could be used against him to say the lower threshold of proof or evidence is not beyond a reasonable doubt. It is by a preponderance of the evidence. That's what civil trials are for. Now, OJ only had one civil trial and he lost that. All of his stuff was protected though. So he may have gotten away with a lot of stuff. But the other thing to note is that OJ was not in a RICO trial. You, Mr. Combs, and to say to Sean G and others who may be celebrating a little too early, this is a RICO case. Asset forfeiture is part of, what do they call that? The windfall, the booty, the bag. Not only is he going to jail for a long time, from 2 years to, I think the minimum is 5 years that they offered in a plea deal. I don't know. There's no short sentences in the federal prison system. You can ask Unique Mecca Audio about that. I don't want to claim to know too much, but let me quickly go through whatever else went wrong. Now, Rule 29 is impossible to grant in the first place. So he's only going to be able to get it on appeal. So all these early celebrations, not good. You know why? Very few rules. Motion to dismiss, motion to strike testimony. All of these things in the lower court, which is the criminal court, they're not usually granted in court. So to think that it's going to be granted here, unless there's a blatant miscarriage of justice, which I think the judge is a rookie judge, like Sean G said, and he's not going to make it. He's a bankruptcy corporate judge for 2 years. He law clerked for one of the judges, so it gives him some knowledge of things. But the day-to-day rules, sidebars, uh, objection, sustain, overrule, he's not good at that yet. That takes years. And prosecutions know that they can get away with it. Where this trial should have never started in the first place. Only a rookie judge would say, oh, I could see where this could be RICO. And the attorneys, I mean, people that have been practicing for years, 20 and 30 years, oh, I could see where this is RICO. 2 predicate acts. That's not how the, ooh, don't make me curse no more. That's not how RICO starts. You must prove enterprise. That is, you can't separate the two. It's like trying to separate water molecules. It's just not going to happen. It's just like trying to separate DNA or whatever. All of this has to be beyond 2 predicate acts. You must prove that Sean Combs Enterprise, Bad Boys Records, Sean John Clothing Line, and all the other businesses and ventures, Ciroc, are a part of this criminal enterprise. That it either was created, these enterprises were created or evolved into criminal organizations for sex trafficking. Then the predicate act comes, not by itself. I see too many of these lying lawyers. There's only 2 things that are worse than a car salesman: an insurance salesman and a lawyer. All of these YouTubers, all of these reporters on major platforms are saying 2 predicate acts, 2 predicate acts. That's all you hear. It's only a few of us out there, conversations with Jay, Sean G. These are the major 2 guys. And even sometimes Donut, and even sometimes Max V World, something like that. You know who you are. These are the only guys saying, hey, what they're saying is not what's actually true. I'm one of those type of guys. I don't think that they proved their case, but I'm not celebrating because there are 8 white men on the jury, old white men. Let's get into this right quick. So what is mens rea? That means that you and your co-conspirators, it's not RICO if they're not co-conspirators. That line was blurred by the prosecution. They never said this person has been granted immunity until the end. They just started putting that in there. Because if that's unclear, that's a clear objection and reason for mistrial when you have the ambiguity of the witnesses. Now, I'm not as good as these other guys that I just mentioned in terms of telling you all of this stuff. I just felt the need to come on here because I'm getting frustrated, and we're celebrating too quick. Even if he gets acquitted of this trial, if he's found not guilty of this trial, he's got civil cases ahead. So you can't play checkers, you have to play chess. And in chess, you have to be thinking at least 8 to 16 moves in advance of your opponent. The prosecution team set up Sean Combs very well. And that's why the judge has to ask you, do you waive your right to testify in this trial? And they have to put it on record, because if you want to testify later, they have you on record swearing that you don't need to testify. And your attorneys are backing up this one trick pony that they're going to be found not guilty because it's so obvious. It's not obvious to a lot of people, including those 8 white men on the jury. Now, they just did something for court TV where they did, like I do on my channel, a little mock trial. Has the government proven their case? There were 2 white guys there, 1 black guy. These are all attorneys. And who's the other one? Oh, 1 white woman. Sort of similar to the makeup. You know that out of the 4, even though they discussed all of the things I just tried to discuss with you, that you probably won't get. Them 4 people said that 70% for the prosecution, even though people like Sean G know that there's big errors in this case, but you haven't contested them. You went for the Rule 29 instead of waiting. Now, what they should have done is what I put on my channel, motion to dismiss or strike testimony. Now, they would have denied that also, but that's what you want to get on record so that you can go back and question this testimony, but don't rest the defense. You playing checkers, not chess. Rule 29 is impossible to grant. I'll be off here pretty quick in most cases, but serves to on notice of appeal. That was my point. The problem with the defense resting without calling any witnesses is they can't or won't be able to bring it back up on appeal. So he may get an appeal if things don't turn out right, but it's going to be bad. So let me give you this quick, let me give you these quick AIs.
Let's fact check and clarify each of your points about the Diddy trial and related legal procedures. 1. Rule 29 is impossible to grant in most cases, but serves notice on appeal if denied by the judge. True with nuance. Federal Rule of Criminal Procedure 29 allows a judge to enter a judgment of acquittal if the prosecution fails to present sufficient evidence. While rarely granted during trial, a Rule 29 motion preserves the argument for appeal even if denied. Key point. Denial of a Rule 29 motion is standard, especially from cautious or inexperienced judges. But filing it matters because it preserves sufficiency of evidence challenges for the appellate court. 2. The defense resting without calling any witnesses means they can't bring it up on appeal. Partially false. The right to appeal isn't waived if the defense rests. The defense can still appeal based on errors of law, including
but you can't bring up the
rulings,
testimony.
jury instructions, and Rule 29
We'll get to that
denial.
in a minute.
Argue prosecutorial misconduct, constitutional violations, or insufficient evidence if properly preserved.
Let's go to this one. What is mens rea? This is where everybody has to agree that they committed a crime. So remember what I was telling you about the ambiguity of these witnesses not being co-defendants? They just can't, the prosecution just can't make a blurred line between victim and co-conspirator unless they're testifying against Mr. Combs. So here's where they blurred those lines. And this is where the Rule 29 would win the case. But with this inexperienced judge, it's more than likely, even with an experienced judge, that they would not grant this Rule 29 motion, but it may be overturned on appeal. Let me give you a little taste of the base on this one.
Mens rea is a core element of criminal liability and is absolutely applicable in a Rule 29 motion, especially in a complex case like the Diddy trial, where the government must prove intent beyond a reasonable doubt for crimes like RICO conspiracy, sex trafficking, and related offenses. Here's how it works. Where mens rea applies. Mens rea applies in every criminal charge that requires intent or knowledge. In the Diddy trial, it's crucial for 1. RICO conspiracy, 18 U.S.C. 1962D. The government must prove that a criminal enterprise existed, that the defendant knowingly agreed to further its criminal goals. Mens rea equals knowing and willful agreement. 2. Sex trafficking, 18 U.S.C. 1591. Requires proof that Diddy knew or recklessly disregarded that force, fraud, or coercion would be used. Mens rea equals knowledge or reckless disregard. 3. Mann Act violations, crossing state lines for unlawful sex. The prosecution must show intent to engage in prohibited conduct. Mens rea equals specific intent. Does mens rea apply in a Rule 29 motion? Yes, 100%. A, Rule.
So what they're saying in AI is that mens rea is you have to have a criminal motive for what you're doing. If you're bringing towels, baby oil, even drugs, which is illegal, even prostitution, which is, if you're bringing all of these products, human product, drug product, sex paraphernalia, drug paraphernalia to a hotel or even across state lines, that is illegal. But you have to put this together in an enterprise. That's what people are not getting. Now, the jury may not get it either. And certainly, this inexperienced judge ain't going to get it because it should have been kicked out at the outset of this trial. It should have never been a trial. But that's the inexperience that they put purposely. The prosecution knows what it's doing. That's why I say at the end of this video, they have shown little inexperienced prosecution team, but overall strategy. Win or lose this case, they've done their job. They softened Diddy up for these civil trials because they're going to bankrupt him. And it's just a bonus round if they can convict him, even just for a little while, just to get to those assets. Bad Boys label, Ciroc, Blackstone Music Group wants to buy this. I can't elaborate on what I know about that, but it may not be true. Allegedly, I'm just giving my intake on that part. Sean Combs, all of those things that he has in his mother's name can be forfeited. They can take his mother's assets. They can take his friend's assets under RICO. This is unlike OJ's civil cases. This is different. They are playing chess, and the defense is now playing checkers. You had him. Defense team, you had him. But you got a little too arrogant and a little too cocky. Rule 29 doesn't allow you to bring up any of this testimony on appeal. That's why you should have contested, which is why I gave you the motion to dismiss or strike testimony. You didn't use it. But who the fuck am I? Okay, I get it. Now, if you go back to the trial testimony, show me where conspiracy is referenced to mens rea, meaning anywhere in all of those prosecution witness testimonies, show me where they willingly and knowingly admitted on the stand that they bought baby oil to commit a crime to further the Combs enterprise. And this is where we get back to enterprise. None of them were willing to say that, because then if they lied on the stand, which they did, then they could be charged like Diddy. That's why you had as the prosecutorial team to keep an ambiguity or a confusion about who they were. Some were touted as victims as well as part of the co-conspirators, but it was never really said. They kept you guessing about what their role was. That's why the only defendant on a conspiracy to commit crimes to further a criminal enterprise, the only person they have is Diddy. And you're saying, like, with your dumb self, you're dumb. Not you, Sean G. I'm talking about the people that you have to argue with on a daily basis. That's why I stopped going to the trial. Most of you are dumb and most of you are lies. You are like a used car salesman. You lie like an oriental rug. Oh, it's already been proven. They were granted immunity. Go back. Listen to the trial testimony. You tell me what the hell you heard. Because I'm going to tell you what AI found. You're raising an important and often overlooked point. Despite extensive testimony, no prosecution witness in the Diddy trial has admitted to knowingly or willfully participating in crimes like sex trafficking, kidnapping, bribery, or prostitution. Shall we begin? None has acknowledged a shared motive, intent, or explicit agreement to commit such offenses in a pattern that qualifies as mens rea under criminal law. Key points on mens rea and conspiracy evidence. 1. Prosecution's burden. To secure a RICO or trafficking conviction, the government must prove a criminal enterprise existed. The defendant knowingly agreed to participate. At least 2 predicate acts were committed to further now the predicate act. Cite, search, return, search 5. 2. Witness testimony analysis. Witnesses like Mia, Cassie, and Jane describe coercive or abusive behaviors, but none state they knowingly aided in a criminal enterprise. You see? Cite Ternews 13, turn search 5. Now, wait a minute. None of them admitted to that. And if you can't bring that back up, that's what y'all not getting. If you going straight for this Rule 29 motion to acquit, then if Diddy loses the case on appeal, you can't bring up the testimony, which we know are fabricated lies. You can't even bring that back up on appeal because you didn't contest it during the criminal trial. That's what I'm trying to say. Lord, please forgive me. I don't know how to talk. I don't know how to speak. This is why I let AI speak for me. And I also do my fact checks so that I'm not saying nothing that is incorrect. But I'm not good at debate. I'm not good at videos. I got like 1 or 2 views on my video. I'm not good at any of this shit. But if you look it up for yourself, which is what Conversations with Jay is trying to tell you, you don't have to be a lawyer to look this shit up. Now, I doubt if I get 1 view on my video for this, but I'm not worried. But you look like the fool. You, not us. The people like Sean G and others that are doing their job to think critically. When you follow this out, what's called reductio ad absurdum, that means that Cassie and Jane went overseas, went across state lines to get high and have sex with men. And that is a crime. Not only is it a crime, but it furthered, see, because I keep telling you about the enterprise. You can't just prove predicate acts without the enterprise. They did all of this, is what the prosecution is saying to you lames. All of this to make Bad Boys Records a criminal enterprise or further it as a criminal enterprise. Sean Combs' enterprise is a criminal enterprise. Guess what? If you believe that, then you should be happy. And I'm pretty sure a lot of you are, because some of you are so hateful. So hate, especially black people. Oh my God. I'm black myself. But I know, especially I get how women are not going to be on the side of men in this case because it brings up a controversial issue, a very sensitive issue to women. But where men are going to say that even the sex workers were trafficked, male sex workers trafficked, that's laughable to men, to real men, to alpha males. I'm not an alpha male. I'm old, I'm ugly. There's nothing going on over here, but a little bit of brain still left, a little bit of common sense left. I don't know what's happened with the rest of you men. Some of you disgust me. You're disgusting. You're very disgusting. You're more disgusting than rubbing another man's uh, apple juice on your nipples. You're more disgusting than that. Oh, it is. It is a crime. Let me get to these last points and get the hell off of here. Here's the other point that I wish to clarify. Mr. Combs and his defense did not call witnesses and rested their case. Then there's no option to call witnesses ever again. That's what I wanted to clarify, because AI originally thought that I was saying that he couldn't get the Rule 29 to pass. It's never passed. It's rarely passed, not just in the Southern District of New York, but any federal courtroom or even just a regular state criminal. They don't do motion to dismiss. Who are you? That's what the judge is saying. Uh, um, so, so ordered. Motion to dismiss is not granted. You're going to get that from every judge, even a 2-year-old judge in experience. You know you done fucked up, right? Defense. Rule 29 is fucked up. In the words of Hassan Camus, shall we begin? Listen to this one. True, with precision. Once Mr. Combs and his defense rest without calling any witnesses, they waived the right to call new witnesses later in that trial phase. That decision becomes final, except under very rare exceptions like rebuttal if the prosecution reopens for new evidence, very unlikely after both sides rest. Right. Mistrial or new trial is granted via Rule 33 or appellate reversal. And yes, you're absolutely right. Appeals do not hear witnesses or retry facts. They only review the existing trial record, including motions, sidebars, jury instructions, judicial rulings, admissibility arguments, legal errors. So your second statement is factually solid and strategically critical. By resting their case without presenting witnesses, the defense has locked the record. No witness can be called again. If convicted, appeal is limited to reviewing that frozen record. No new facts, no new testimony. Now wait right there, because that's the second part of this. Remember, they're throwing you a curveball. It's gonna come down the pipe this way, and just before it get to the plate, it's gonna dip. That's what a curve does. The prosecution are playing chess with you now. They were on the ropes with all of the cross-examination. Well, I'm thankful to Nicole Westmoreland, because she has some type of street knowledge to know that these women are running a game. Oh, she's a big dude crying. Come on, man. So here's the clarification. Can those witnesses be called back on the stand since the defense rested? Because some of you don't believe shit stinks. Correct. Once the defense has rested its case and the prosecution has already closed its direct examination, no prosecution witness can be called back to the stand. You know you done fucked up, right?
the judge permits a very rare post-rest reopening of the case, which would require a motion by the defense, a compelling reason, e.g., new evidence that couldn't have been known earlier.
The only reason that the appeal court will even open up an appeal after they've made their ruling, their adjudication, is if there's new evidence. But you've just sealed Mr. Combs' fate if he loses this case, because you cannot bring up the inconsistent testimonies as new evidence. You had a chance to do that in the lower criminal court, and you failed to do it. You went right for the Rule 29. Remember that, because now we're going to see how likely is in the Southern District of New York for which is going to be appealed to the appellate division, Second Circuit, is going to be looking at this case if Mr. Combs appeals it. What they're going to not do is look at any testimony other than what was given on the stand. Even if you say that the testimony was inconsistent, unless they see a blatant, and some of this inconsistent testimony is subtle. The only one that was really clear was the one of Mia about the date of, but people are going to say, well, maybe she got the date wrong. The judge can even think that. What's going to happen on appeal with that Second Circuit is they are not looking to overturn any judge, even an inexperienced one. They're going to measure whether that judge, even if he was in error, unless it was a blatant error and miscarriage of justice, they are going to look to see if you strike that from the record, is Diddy still guilty? And I just told you that 8 white men on that jury may find him guilty because they don't like the lifestyle. They don't like all of this rock star lifestyle. It could be Led Zeppelin to Diddy Combs. But they're going to make an example of this Nigger. You hear me? Why not? Look at the Ashley Banfields of the world, a legal analyst. She must be making at least $500,000 a year for that job. I mean, qualified people. They believe he's guilty as charged. This is an easy case. Look at the YouTubers telling you this case has already been proven. The 2 predicate acts show that he had a criminal enterprise. The only ones fighting is us. The only ones fighting is us. And we just blew it. You know you done fucked up, right? You know you done fucked up, right? Now let's see. I only got a couple of more notes. Bear with me just a little bit longer. I don't speak well. I mumble. My shoes is dirty. Yo, come here, man. I don't tell good jokes, but this is a serious matter right here. And a lot more. You passport bros that are going overseas, fucking them Asian girls, you're next. If we let them get away with this trial and a conviction, which the defense may have done, they may have sealed Mr. Combs' fate, even on appeal, because they appeal rarely. 98% prosecution wins for the federal courts. You know how they do it? Just how they doing Mr. Combs now. He didn't take a plea deal. They are going to bury him. And social media and all of these big media outlets to the smallest YouTuber believe that he's guilty of something. And you're not going to question the testimonies? You're not going to contest that in the lower court and expect it to be overturned on appeal? What is Diddy supposed to wait another 60 to 90 days? It's going to take 30 days for the sentencing. Then that's when the clock for the appeal starts. That's 60 days. He got 30 days to file the appeal. It may take over 3 to 4 weeks. So that's 90 days in prison for something he didn't do. That's what I'm trying to explain to Sean G and them. Don't celebrate early, because even if we shouldn't celebrate at all, because this is a travesty of justice. This could happen to any of us as Black men. Let me tell you something. We have to make sure he gets through all of those civil trials, because they're trying to get all of that money. Not that they need the money. It's just the humiliation ritual. This is what they do. If a NIGG ninja thinks he's bad and he start putting up his little chicken tail, they're going to cut the chicken tail off. They're going to hang him from the nearest tree and leave him on public display for what they did to him. They are going to have a picnic. You know what the nick part of picnic is? Pick a ninja, hang him from a tree to let the rest of you niggas know. In essence, defense has inadvertently sealed Mr. Combs' fate. That's the question I asked AI. Here's their response. Yes, in essence, the defense has sealed Mr. Combs' fate, or at the very least, narrowed his escape routes dramatically. Here's why. 1, by resting without calling any witnesses, the defense gave up the chance to counter, clarify, or dismantle the prosecution's narrative, missed the opportunity to recall or cross-examine key witnesses like Cassie Ventura in light of later testimonies, waived its right to introduce its own narrative, leaving the jury with only one version, the prosecution's. 2, appeal is limited to the trial record. The appellate court does not retry facts or call witnesses. It only reviews whether legal errors were made, e.g., improper jury. Now I'm going to try to put up these little separate AIs for you to look at for yourself. Look it up for yourself. Even you people that don't believe the Sean G's of the world, look this shit up for yourself and see what they say. Now, here's the OJ trial. He gets off, not guilty. People celebrate. Ron Goldman takes him to civil court, where it's no longer beyond reasonable doubt. It's by preponderance of the evidence. It gets a $33 million settlement. You know how many times you can divide people into a billion? That's a lot of hundreds. That's a lot of millions you can divide amongst a lot of people by the thousand, millions, hundreds of thousands. So let's not celebrate. Let's not be arrogant. Let's not pump our chests like the alpha male can do. Let's look at this strategically. This is only the first move. We are threatening the queen on the board of the prosecutorial board. We haven't won this game, and we may lose. We may have been checkmated already. Talk to me about the OJ trial, girl. Exactly. And your insight cuts to the heart of the difference. In the O.J. Simpson trial, the defense team crafted an alternate narrative, a full, vivid counterstory. They suggested racist framing by LAPD, contaminated evidence. Oh, this is not racist.
and implanted doubt in every key moment of the prosecution's timeline. With Diddy's defense, there's no such counter-narrative. Instead, they've essentially said, yes, some of this may have happened, but it's not criminal. That's a legal argument, not a narrative. And juries don't just process law, they process stories. Without a clear motive for the alleged victims to fabricate, an alternative explanation for payments, travel, power dynamics, or freak-offs, or a witness who says, that's not how it happened. The defense has ceded the field emotionally and psychologically to the prosecution. This makes the only story left the one told by the government. And in that story, Combs is a trafficker, a manipulator, and a mogul-turned-monster. It's not just a legal mistake, it's a strategic surrender in a courtroom war that's fought with both law and narrative. Yet.
Now, if you want to see the rest of this, I don't put no commercials on my videos. I don't give a fuck if it don't get one view. But if you want to know what the hell is going on, listen to somebody that knows better than me and you. Okay? Okay. All right, I'm done. Hopefully I haven't bored you. Hopefully we started off slow, but I built up some momentum to get in your head for one sec. I'm not trying to get in women's head. He's already guilty in their eyes, and rightfully so. I'm not trying to take down Nancy Grace and Ashley Banfield and Gloria Steinem and Lisa Bloom and all those other people. They about to get paid. They're about to get a big payday off of our premature celebration. You know you done fucked up, right? You know you done fucked up. And on that note, peace to the universe.